This is case number 2513691 FH. We're here for our final status conference. This case is set for a jury trial starting May 19th. Is there a final offer that the people are making?
Yeah, the offer is plead to counts 1, 3, and 5. We'll dismiss 2 and 4. That would include the felony firearm. I have sentencing guidelines at 2 to 17 months. We would give a no prison recommendation in exchange for a plea, but the weapon would be forfeited as part of the plea as well.
All right, Ms. Frisbee, is that your understanding of the offer?
It is, Your Honor.
And have you discussed that with Mr. Isaac?
I have, Your Honor.
Is that true, Mr. Isaac?
Yes.
All right, and what does he want to do today?
Must have keep it on the docket for a trial.
Is that true, Mr. Isaac?
Yes.
Okay. All right, so just want to run this through with you to make sure you understand, because after today, no plea bargains, no sentencing agreements, right? So the offer is to plead to count 1, a 4-year felony with assault with a dangerous weapon. Dismiss count 2, which is a felony firearm, which has the possibility, if you're convicted of that, of 2 years mandatory in prison, consecutive to any other felony that you're convicted of. Do you understand that?
Yep.
Plead to count 3, another assault with a dangerous weapon. Dismiss count 4, a 4-year assault with a dangerous weapon. Plead to count 5, a 5-year carrying a weapon with unlawful intent. Do you understand that so far?
Yes.
The prosecutor, with his reduction in charges and getting rid of the felony firearm, the prosecutor has provided an estimate. The guidelines will be 2 to 17. Do you understand that?
Yep.
If the court chose to sentence within those advisory guidelines, you could get as little as 2 months, but you could get as much as 17 months, which could be prison. You understand that?
Yes.
After today, that's not going to be an option for you.
Yep.
If you're convicted at trial of all of these offenses, your guidelines would be most likely be higher than 2 to 17. Do you understand that?
Yep.
And you'd be looking at the mandatory consecutive sentence of 2 years. Do you understand that?
Yes.
You've discussed all that with Ms. Frisbee, is that right?
Mostly, yeah.
Okay. And it's your decision after discussing this offer and my explanation that you do want to continue to trial. Is that right?
Yes, sir. Yep.
And I don't know anything about your case. I'm just telling you that with this no prison recommendation, that's a good deal if the prosecutor can prove the case. Do you understand that?
Yeah.
All right. And you also understand that after today, the court's not taking a plea to reduce charges or any sort of sentencing bargain. So your choice is to plead guilty as charged, which would be the 2-year mandatory minimum consecutive, or go to trial. You understand that?
Yes. Yep.
Okay. All right. Sounds like you know what you want to do. So we'll see you here in May for your trial.
Okay. Thank you. Okay.
This is Daniel Dean Dunlap. It's case number 2513706 FH. Mr. Dunlap, you are set for trial May 19th and 22nd. The court's been advised that you want to enter a plea. Is that right?
Good check.
Okay.
He needs the headset.
Okay.
You better?
Yes.
Okay, so we'll start over. So this is case number 2513706, People versus Daniel Dunlap. Mr. Dunlap, you're currently set for trial on May 19th through the 22nd, but the court's been advised that you want to enter a no contest plea. Is that correct?
Yes, sir.
All right, why don't you raise your right hand for me? You solemnly swear, oath, or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Mr. Welborn, would you put the agreement on the record, please?
Yes, Your Honor. Defendant's going to enter plea to count one. The habitual offender fourth offense will be amended to habitual offender second offense. I calculate sentencing guidelines at 2 to 21 months, Your Honor. We will give a no prison recommendation in exchange for a plea. This change in offer is due to some correspondence with the victim on the case, Your Honor.
All right, Ms. Frisbee, is that your understanding of the offer in this case?
It is, Your Honor. This is
All
no, and this is no contest plea. We supply the court with some documents.
Yep.
Actual basis.
All right, so Mr. Dunlap, the charge that you're entering a no contest plea to reads as follows. That on a date range of September 1, 2025 to October 10, 2025, that you were in Merrill Township, Nuevo County, state of Michigan, that you committed the crime of larceny in a building, that you did commit the crime of larceny by taking tools from a shed. And this is a felony, which carries up to 4 years in prison and or $5,000 fine plus cost. To understand the charge and the maximum penalty.
Yes.
They're reducing the habitual offender fourth to habitual offender second, which means you have at least one prior felony conviction. What they've alleged here is that you were convicted September 29, 2025 in the 11th Circuit Court for Luce County of a delivery manufacture of marijuana. Do you have that prior conviction, sir?
Not in 2025.
No, 2005.
2005, yes.
All right, you have that conviction?
Yes.
All right, so that habitual offender second makes it possible that your maximum penalty could be increased from 4 years to 6 years, and the fine could go from $5,000 to $7,500. You understand how the habitual offender second could increase your maximum penalties.
Yes, sir.
You also have a sentencing agreement that you not be sent to prison. You understand that?
Yes, sir.
And that your sentence be consistent with the advisory guidelines. You understand that?
Yes, sir.
The prosecutor has provided an estimate of 2 to 21 months. Your actual guidelines could be higher or lower than that. But as long as 12 months falls within the range of guidelines, as I score them at the time of sentencing, you have an agreement that any upfront jail time would not exceed 1 year. You understand that?
Yes, sir.
You would also be consenting to probation. You understand that?
Yes, sir.
And there may be restitution owed as well. Do you understand that?
Yes, sir.
Is that your complete understanding of the plea agreement in this case?
Yes, sir. With one thing, my understanding is you did receive the tools back from the pawn shop. Yes, sir.
It seems like maybe some, but I'm not sure if all of them were recovered. I don't know that. So restitution is a possibility. Understand that? All right. You've had sufficient time to consult with Ms. Frisbee about your charges and this plea agreement?
Yes, sir.
And subject to the plea agreement, how do you wish to plead?
No contest, sir.
All right, and that's for civil liability, Ms. Frisbee?
It is, Your Honor.
All right. So, Mr. Dunlap, with the no contest plea, you're not admitting this charge, but you're no longer denying it. You understand that?
Yes, sir.
The court's been provided a copy of your preliminary examination transcript and also a copy of the police report. And if I find that the elements of the offense are contained in those documents, I would find you guilty. Do you understand that?
Yes, sir.
This conviction would be on your record, You understand that?
Yes, sir.
And you'd be subject to sentencing according to this agreement. You understand that?
Yes, sir.
You also understand that if I accept your no contest plea, you're giving up the right to have a trial of any kind.
Yes, sir.
You also understand that you're giving up the rights that you would have at that trial.
Yes, sir.
We've listed those rights for you on a written advice of right sheet that you signed on March 27th. Did you read that document?
Yes, sir.
Did you understand those rights?
Yes, sir.
Have you gone over those with Ms. Frisbee?
Yes, sir.
Has anyone threatened you to get you to make this plea?
No, sir.
Has anyone promised you an outcome different than what we put on the record?
No, sir.
Are you entering this plea of your own free will?
Yes, sir.
You understand that if I accept your no contest plea, you're giving up the right to later claim that this plea was not your choice.
Yes, sir.
You understand that I'm not bound by this plea agreement, but if I don't go along with it, you can withdraw your plea.
Yes, sir.
Do you now give up your right to have a trial of any kind and all the rights that you would have at that trial? And do you still want to plead no contest?
Yes, sir.
Mr. Walburn, any objection if the court reviews those documents?
No, Ms. Frisbee indicated that's what we were gonna use prior to the hearing. We have no objection.
All right, the court has had an opportunity to read those documents and do find that the elements of this offense are contained therein. Are the attorneys aware of any promises, threats, or inducements which have not been stated on the record?
No, Your Honor.
No, Your Honor.
Is he competent to enter this plea?
Yes, Your Honor.
He is, Your Honor.
As the court comply with MCR 6.302?
I have, Your Honor.
Yes, Your Honor.
All right, the court does find the plea to be knowing, understanding, voluntary, and accurate. I'm going to refer the defendant to the probation department in preparation of a pre-sentence investigation report. We will set sentencing for May 12th at 9:40. Need to talk with Mr. Zira before you leave today, sir.
Thank you, Your Honor.